Good evening again. I'm Benny Paul from the Campbell River Mirror, and I would like to start by acknowledging that we are on the traditional territory of the Likwita Nation. The topic of our discussion today is understanding the rights and title of Indigenous people in Canada. And to elucidate this topic, we have with us prominent lawyer and author Jack Woodward, who specializes in Indigenous law. Now, since 1970, Jack has fought numerous cases for First Nations, including the Chilcotin First Nations precedent-setting Aboriginal title case. Jack is also well known for drafting Section 35 of the Constitution Act 1982, which enshrines Aboriginal rights, and he is also the author of Native Law, Canada's leading publication on the topic. Thank you so much, Jack, for joining us this evening.
Hello, Benny. Thanks for that kind introduction. Yes, it's great to see so many people here tonight. And I even know many of the people on this call, so it's like a family reunion in a way.
So Jack, let's go to the very beginning. Where do Indigenous rights and titles stem from, and why do they exist?
Well, the Aboriginal people of Canada, and by the way, there's 5 different words that are used: Indigenous, Aboriginal, First Nations, Native, and Indians, and they're all correct. You don't have to be pedantic about it. Anybody, you can use whatever word you want. We all are talking about the same group of people who were here first. That is the people who lived in what is now Canada before the European settlers arrived. And it's always been a principle of Canadian law, British law before that, that when Britain assumed sovereignty over a territory, they just took over the government. They didn't take over the land rights. You take an example of a huge country like India, or the huge countries that were British in Africa. When they took over those countries, when the British Empire was at its height in the 1800s, they didn't displace the people who owned the land. They just displaced the governments. And that's the same here. In Canada, the law has always been that the Indigenous people continue to own the land that their ancestors owned, but that the British government and now the Canadian government assumed the overall sovereignty of the territory. And so the issue really, it's a really simple issue. It's really whether or not Aboriginal people can inherit the land that their ancestors owned. It's really like an estates problem. It's like, has the correct succession happened from the true owners to their descendants? That's what it's really about, Benny. It's about the right of Indigenous people to inherit from their parents and grandparents and great-grandparents.
Right. So looking back at the laws, do we go back to the Royal Proclamation? And is this where it was, to a certain extent, put down on pen and paper, or, paper, as I would say?
Well, it was paper. In 1763, when Canada was first set up, the British took over after what I call the First World War. That was the 7 Years' War. The British took over this huge territory in North America that used to be French, and part of it was Spanish. And in place of what used to be the old French regime, which was a monarchist system, the British instituted a democratic system. So that it was quite a progressive document, the Royal Proclamation. It says democracy, the rule of law. They set up courts. And the purpose of the courts, it's really interesting when you read it, the purpose of the courts was to defend the land rights of the inhabitants. And the inhabitants were the native people. So the original courts in Canada were set up for the exact purpose of protecting the land rights of the native people. It says it right on the face of the Royal Proclamation, which is our fundamental constitution. And then, of course, the Royal Proclamation goes on at length to talk about the protection of Indian land rights and Indian hunting rights. I mean, that's really what it's all about. So our fundamental constitutional document, that's about protection of Indian land and Indian hunting rights. That's what it says. And so that's always been part of Canadian law ever since Canada was invented in 1763.
So right after the Royal Proclamation, another act or another law that stands is the Indian Act. And now historically, this has been very controversial because it has also denied the rights of Indigenous people. So where does that fit in?
Yes, well, the Indian Act, is everybody calls it down, but I'm the only person who waves a flag for the actual good part of the Indian Act, which is found deep inside the Indian Act is the perpetuation of the rule that was set out in the Royal Proclamation. So the protection of Indian lands is found in the Indian Act to this day. And so that's a continuity in Canadian law for over 250 years, that fundamental protection of Indian lands from any kind of takeover or expropriation by governments. So there's a lot of things that are bad about the Indian Act, but that one thing continues to this day. There's some controversial things in the Indian Act too. For example, the protection from taxation. And when you think of where that came from, a lot of people hate the fact that First Nations have special tax exemptions. Well, that goes right back to 1763, is that not only can the king not take Indian lands from them, he can't tax them. So that was part of the protection of the lands of the original tribes and nations, was that they're protected from any way of being expropriated or undermined.
So how did that change? I mean, if we're still looking at the laws which enshrine all these details, right now we're not at the place, or do they still exist, or are they buried under a lot of bureaucratic processes?
No, the laws, the fundamental laws of Canada, and Canada is unique in this respect, still protect fundamentally the rights of the original inhabitants. And they're not. It's not that unusual. These are the same rights that all Canadians enjoy, which is the right to inherit the lands that their parents and grandparents and great grandparents owned. The part that's unusual is the protection of the rights to hunt and fish. That has always been a part of Canadian law. And whether you're talking about Aboriginal rights or original proclamation rights or treaty rights, it's always there, the right to hunt and fish. And what those have turned into in modern times is very powerful environmental rights. So you can't have the right to hunt without game, and you can't have the right to fish without fish. So you need habitat for those creatures. You need to have a healthy environment. So the rights of Indigenous people in Canada are far more powerful at protecting the environment than any statute that's been passed by Canada or a province. They're far more powerful, and they are, increasingly you people hear, and they sometimes get annoyed about the fact that somebody wants to build a pipeline or develop some big project, and that the people who are objecting to it are the First Nations quite often. Well, there's a really good reason for that. And the good reason for that is that they're the only people that have powerful legal rights to do anything about it. Governments make the laws and they can do what they want, except that they can't take away the rights of Indigenous people. Now, at a time when the environment is a big issue, and protection of the environment, protection of habitat in particular, is a big deal, we all end up looking to the First Nations to advance their rights, because their rights are the only way to protect the environment under our Canadian legal system.
Right. Now, since we're already on the topic of history and where the rights and titles stem from, there was also a period in history when BC or the province was signing treaties with First Nation, and then it stopped abruptly. Do you want to speak about that? Like, why did that happen, or how does that fit in? Or could a lot of things that we're dealing with today have been avoided had those things been done back then?
Yeah, it's a very good point, Benny, is that everywhere else in North America, and I want to point out that Canadian law and American law are pretty much the same on this point. Throughout the United States and throughout everywhere else in Canada, just about, treaties were signed with the First Nations, and so there was a formal agreement that protected some of the rights, but also provided for the taking up of land for settlement and development. That didn't happen in British Columbia, except in a few small places. The city of Victoria, for example, in the Saanich area. But by and large in British Columbia, treaty making stopped. So Governor Douglas, way back in the 1850s, he started making treaties, and he ran out of money. And the Legislative Assembly wrote to head office in London, England, and said, we need more money to sign these treaties. And London wrote back and said, sorry, you're going to have to raise your own money. And they didn't have the money. They couldn't afford to buy the land from the First Nations. It was interesting. I was looking at a book this morning called Papers Connected to the Indian Land Question. It was published in 1875. So they called it the Indian Land Question back in 1875. So 145 years ago. And that's still a question. They got stuck. They got stuck by not having enough money. And of course, there's a reason for that. British Columbia is valuable, and the First Nations were rich. They owned British Columbia, and they didn't want to give it up for free. They were, they knew what they were doing, and the settlers didn't have enough money to buy it, and London wasn't chipping in. So that's where the impasse started, and we're still there for much of the province.
So holding on to that point, Jack, so despite Indigenous rights being constitutionally protected, are they absolute when it comes to the Canadian law? Can they be challenged by governments when it comes to resource development and management? And like you said, because BC is resource rich.
Yes. Well, no constitutional rights are absolute. Whatever constitutional rights you're talking about, there's always an exception or a way to qualify it or modify it, and that's true for Indigenous rights as well. There's a famous doctrine set out in the Delgamuukw case by the Supreme Court of Canada that says that there's an inherent limit on Aboriginal title, and that limit is the First Nations own the land, but they're not allowed to destroy it. So it's interesting. The governments, both of Canada and British Columbia, claim such a degree of ownership that they would have the right to destroy land, but the First Nations, when they own it, they would not have that right. But this leads to a more complicated thought, which is about whether or not it's a good thing or a bad thing for First Nations to assume their rightful position as owners of the land in British Columbia. You might say that the First Nations are more likely to be better stewards of the land than the present system, where you have governments that are somewhat remote from local territories, both either in Victoria or as far away as Ottawa, managing the resources. But First Nations are always still right there, right where they always were, close to the land, close to their resources. And generally speaking, it's hard to generalize, but generally speaking, First Nations are somewhat more respectful of the natural environment and the lands around them. And you might expect that they would have a natural inclination to be better stewards of the land and the resources. I think that's probably what would happen. And of course, there will be exceptions. But the big exception, and I'm answering your question here, Benny, is that the big exception is that when First Nations do assume ownership of their land, they, unlike federal and provincial governments, are not allowed to destroy the fundamental economic value and productivity of the land. So they're forced by our legal system to be good stewards.
So back to that question again, Jack. But for any interference from either levels of government, the province or the federal government, it does require justification, prior consultation, and consent from these First Nations, right?
Well, once they own the land, but we're not there yet. We're still in a situation where most of British Columbia is managed and operated as if the Crown owns it. And it's called, in fact, in the statutes, it's called Crown land. And much of that Crown land isn't actually Crown land. It actually belongs to the First Nations, and we haven't got there yet. The only people who have a declaration of Aboriginal title are the Chilcotin people up just west of Williams Lake. And for an area, not that big of an area, not as big as the Saanich Peninsula, they have a declaration of Aboriginal title. And the trouble with that land is that it's a high, dry, 4,000-foot plateau where the trees are not very productive. In fact, they're not worth anything commercially, and they had a big forest fire and they all burned up a couple of years ago. So it's a situation where they won their case. and they're happy that they own their land. They are the rightful owners, but it hasn't made any economic impact on the province because it happens to be an area that's not of economic value to the province. That's going to
Right.
change. That's going to change when some of the big cases on coastal British Columbia come to court.
Right. So, talking about resources and economics, why are title claims still being resisted by governments? So, are we going to look at it from the context of, like you mentioned, economic impacts and resource rich areas, right? And I mean, it was maybe, but despite Chilcotin being, the case was fought for 25 long years, Jack. And, if you're saying that other land titles come from more resource rich areas, it's quite a question there.
Yes, well, it's tough, to be a little bit sympathetic to governments. It's tough for them. They are elected by the majority, and the majority are not Indigenous, and they're accountable to their constituents, and they have to sort of put up a fight, I guess, somehow put up some resistance to the transfer of wealth that's about to take place. But over the next generation, we're going to see a replacement of ownership of large parts of the province um, from what is nominally called crown ownership, but I want to look behind that in a minute, to Indigenous ownership, for not for the entire province, but for fairly large chunks of it. And the reason I put crown ownership in quotes is that, unfortunately, the history of British Columbia has been a history of resource giveaways, so that now much of the forests of British Columbia are actually owned by corporations that are owned by foreigners. So, like, the province doesn't belong to British Columbia now anyway. But I'm afraid that's going to change. That is going to change. The forests will belong, by and large, to First Nations, uh, and the crown won't have a say in that. That's the thing about it, is that it's a big shock and a big surprise and a big adjustment for the system to get used to the fact that in large parts of the province, there's going to be a different landlord. It's going to be a local landlord, not a foreign landlord.
So does the shift in ownership or the foreseen shift in ownership, right, from say being crown control to First Nation sovereignty or self-governance out there, is that something that's an impediment when it comes to um, giving away the titles, or like why we've been seeing long years of court cases and judicial battles when it comes to Aboriginal title claims?
You've asked two questions. The first one is about the long years of court cases, and I think that the answer to that is that we've actually had very little litigation. The First Nations of British Columbia are not inclined to go to court. There's over 200 First Nations in British Columbia, and they generally don't go to court. They are patient, they are negotiating, they are careful, and they're cautious, and also they're poor, so they don't spend a lot of money going to court. It's surprising. If this was a more litigious society, a lot of this would have been resolved a long time ago. But First Nations are civil and polite and careful, and they just don't go to court. So Chilcotin came down in 2014, Supreme Court of Canada decision. It's coming up to the 7th anniversary. Um, you would have expected a flood of litigation as a result of that. It just hasn't happened. Instead, First Nations have gone to the negotiating table and been polite and been civil, perhaps to their own detriment. So that's the first part of the question. But the other part of your question is more of is about the transfer of wealth that's going to happen. And again, we all want to have we all have our opinions about what about that is, but I want to take this opportunity to paint a happy picture of that. The fact is, First Nations are British Columbians, and they are our neighbors, and they are here, and they're not going anywhere. And so that's a good thing for local control of the resources. And of course, they're interested in making money. They're interested in exploiting the resources just like anyone else would, probably in a more sustainable way than than has been in the past. And so we're likely to see a situation that's better for the economy. First Nations wealth is always better for the economy because the money is here in the province, in the country, and it's not going offshore.
Hi, Jack. Again, staying on the topic of economics and resources and vested interest, etc. You've mentioned that there is a correlationship between economics out here, economic interests and titles. So, like, for example, let's talk about that in connection with the Nuchatlet First Nations land title case. And for a background, that's also a case that you're fighting in court next year. For background, for those who are unaware of the Nuchatlet First Nations land title case, they have a trial date set for next year, and Jack is also the lawyer who's fighting that case. So now connecting those two instances, because we're talking of Nootka Island, which is resource rich when it comes to logging or when it comes to cedar wood, and now they filed the case back in 2017, and it's been 5 years since, for them to get the trial date. So let's make that correlation out here. And how do you explain that?
Well, thanks, Binny, for asking about the Nuchatlet case. I just want to acknowledge that on our screen today is Archie Little, who's one of the counselors and elder and the speaker for the Nuchatlet First Nation. He's on this call. So hello, Archie. I'm thrilled that you mentioned Nuchatlet case. Yes, the trial date is March 15th, 2022. Seems like a long time away, but the time will go quickly. Nootka Island, I have a show and tell here. Nootka Island is where Captain Cook arrived in 1778. And so it's the first place. It's also at the same time the Spanish arrived. So the first Spanish explorers, they met at Nootka Island, and in fact, on the old Spanish maps, the whole western and northwestern part of North America was called Nootka. They called it Nootka because they named it after Nootka Island, which was the most important place. Of course, it's become a bit of a backwater now, but it certainly wasn't in the 18th and 19th century. Nootka was famous. And so that's an interesting place because that's where the first Europeans came, and that's where the first coastal claim of Aboriginal title is going to be heard and determined by British Columbia Supreme Court, starting in a trial next year. It's actually the second case. The first one was the Calder case, brought by Tom Berger 50 years ago, the Nisga'a Nation. I was talking to Tom Berger on the phone yesterday, and we were excited about the fact that now there's another case. He took his case in times when nobody had really thought you could litigate these cases. Remember the history of this is back to the Bad Indian Act. It was illegal for Indians to hire a lawyer for land claims back before 1951. It was a criminal offense for a lawyer to take a lands claims case. And there were people who went to jail simply for the fact that they filed, for doing the kind of work that I do every day. That would be a criminal offense before 1951. And so Tom Berger was one of the very first, after that law was repealed and people woke up and realized that they could in fact go to court to enforce their rights. Tom Berger was one of the very first to do that. He was a pioneer in that work for the Nisga'a Nation, and he encountered the first of a long series of procedural roadblocks that prevented those cases from going through. And following his example, other lawyers have one by one gone to court to beat away those procedural roadblocks. Chilcotin succeeded, got through them all, got to the end of the day and got a declaration of title, and now the Nuchatlet are going to be the second. And that's an amazing thing that we're at that stage where, huge transfers of wealth. I'm proud to be a Canadian about this because big transfers of wealth and the creation of justice for people at long settled claims that are finally resolved in a legal way doesn't happen in every country, but it's happening in this country. And it's something that we can all be proud of, that we're doing this difficult thing in an orderly, sensible, legal, measured way.
So talking about that, Jack, we've established or you've touched upon quite a few laws and rights that exist in the Constitution. Now we also have in the province Bill C-41 or the DRIPA Act, the United Nations Declaration for the Rights of Indigenous Peoples. Now, how does this strengthen the case, or where does that fit into especially because BC has adopted it as legislature? So how does that fit in with understanding the rights and titles of Indigenous people out here in the province?
Well, it's very ambitious of the province to have passed that statute, and they're to be congratulated. Although, unfortunately, they passed the statute a little over a year ago with no plan as to how to implement it, and they still don't have a plan, at least not one that they've told me about or anybody else. So it was a great thing to pass that statute, but it's left everyone thinking, okay, do something, and they haven't yet. The statute says that the province will not take any measures contrary to the United Nations Declaration. So that's the minimal threshold. So anything the province does that runs contrary to the United Nations Declaration is illegal. And that means that an awful lot of what the province is doing right now is illegal by their own statute, because the statute says that they will not deny the rights of Indigenous peoples. So do Indigenous peoples actually have to go to court and prove their rights? I mean, that's where we're at. And the province has raised expectations sky high, which is good. It's good to have a target, but we've got that target now, but the province is not getting us there very fast. I mean, it's tough, and it means that a lot of, for example, civil servants, well-meaning civil servants who come to work every day, and they're faced with two things. On the one side of their desk is, for example, the Forest Act, and on the other side of their desk is the Declaration on the Rights of Indigenous People, which tells them to do the exact opposite of what the Forest Act says. Now, what would you do if you were a government employee faced with that? And I just give that as a kind of a simple-minded example, but that runs across the whole of the government of British Columbia right now, because everyone in government is now faced with two different mandates: the existing statutory mandate and the new Rights of Indigenous Peoples mandate, which is, in many cases, the opposite. That's got to be worked out.
So moving forward, Jack, there's obviously the fact that, judicial reviews are going to be changing and evolving as we go forward, as they have historically. Now, moving on and going forward, where are we at in upholding these rights and titles of First Nations and Indigenous people? And also, what's the future like? How does it look like? I mean, do you think there's going to be at an equilibrium where where law systems, acts, provinces, federal government, everyone will be, on the same level in not just dispensing these rights, but acknowledging them and upholding them as well?
Well, Canada is a complicated country, more complicated. We have a more complicated constitution than almost anywhere in the world. And it requires a great deal of caution and tolerance, in fact, because if you're a Canadian, you have to tolerate the fact that people in Quebec speak a different language. If you're a Canadian, you have to tolerate the fact that other provinces have different agendas about how they want to run the show. And you have to tolerate the fact that First Nations have special rights, always have for 250 years. And nothing has changed in that regard. The only thing that is changed is that as resources become scarce, as the population increases, it becomes more noticeable who owns things. And especially as the legal system is getting more sophisticated and more advanced about this, the rights of First Nations are being enforced more vigorously. And so people notice that, and it does require, I mean, that's a good thing. Canadians are tolerant, and we have to continue to be tolerant because we have to live together, and we have to accept the fact that each other have different rights. And I just want to emphasize this, the point about Indigenous rights. This is not something weird or unusual. It's just the normal rights that all Canadians have, which is to inherit the land that their ancestors owned. It's just that was denied at one point. There was a break in legality And it wasn't our fault. Those of us in this room, it's something that happened over 100 years ago, and it's a mistake that we're now having to fix. It's going to be difficult and expensive to fix it, but we will fix it.
Thank you for that, Jack. We do have an interesting question that's come in where one of the audience has asked that First Nations people say the title is still theirs. So if corporations can lose their title to forest lands through recognition of lands and title, for example, if they win the case or treaties are signed, etc. So where does this leave private homeowners who are on the territories of First Nations?
So you've asked two questions. One is corporations that have interests in Crown land, and the second is private homeowners. Well, let me deal with private homeowners first. So far in the Canadian legal system, there's never been a case where someone who owns fee simple, what we call fee simple, which is what we think of as private ownership, the kind of ownership you have if you buy a house or a condominium. There's never been a case where First Nations rights or claims of title have upset that. The claim turns into a claim of compensation against the government that originally alienated that land. So nobody's going to get kicked out of their house. But forest companies may well lose their licenses to cut trees because their licenses derive from the Crown. And they don't have private ownership. They simply have rights derived from the Crown. And what happened in Chilcotin was, it's really important to know what happened in Chilcotin. In Chilcotin, the Supreme Court of Canada said the Forest Act no longer applies to that territory that was claimed by the Chilcotin. So there's an area in British Columbia where there's no Forest Act. It doesn't apply. And that's going to happen in other places in the province. And so if you're a forest company and you have a license that you got from the province of British Columbia under the Forest Act, that is a worthless piece of paper. So that is a problem. And those forest companies are going to go straight to the province and say, hey, you sold us a worthless piece of paper. That's the expensive part of settling Indigenous claims, and that's what's coming around the corner. However, you know, you might notice that in terms of the old growth forests of British Columbia, they're almost all gone. So what the First Nations end up with is a land that has been pretty badly abused at this point. The land that's under claim on Nootka Island has been 80 to 90% logged. Magnificent old growth ancient cedar forest is 80 to 90% gone. So what the new Chatla will get when they win the case is the remaining 10 to 20% of the forest they originally owned. So far in Canadian law, there has not been an opportunity to go back, to look back and get damages for previous takings of the land. It's a forward-looking project. So I expect the new Chatla will win, but when they win, they will get the land in its damaged state, and they'll have it from then on. The big forest company, I'm expecting, Western Forest Products, will end up with a worthless piece of paper, and they'll have to go to the province and say, province, this is no good anymore. You're going to have to make it good to us. And that's a problem for the province of British Columbia. We're all in that. We have to figure out how to deal with that.
I do have another question, but before that, I would also like to tell the audience, if anyone does have a question at this point, you can just send it in the chat, and time permitting, we will raise it up with Jack. Now, Jack, moving back and onwards to one of the points that we had discussed earlier. Say, once rights and titles are recognized or treaties are signed and court cases are won, it's self-governance, like, for example, the Nisga'a Nation, they're following a model of self-governance and self-determination out there. Now, after treaties are signed and after titles have been transferred, does the government, the federal government or the provincial government have the right to interfere, or on what grounds can they interfere?
Well, that's an interesting question, Benny. You've drawn a link between the success in an Aboriginal title case and the mode of government, and there's not necessarily a link. All that the Aboriginal title does is says that the First Nation, its land base is expanded from what right now is little tiny Indian reserves to a proper land base. It's the same government. There's no change in government, and it's still a tripartite system where where Canada is governed by the federal government, the provincial government, and the First Nations government in their territories. And the relationship between those three levels of government doesn't change. So there, I know that there is a current of opinion that an Aboriginal title, a successful Aboriginal title case, represents sovereignty and self-government. It's not necessarily that direct of a line under our legal system. Of course, if there is land, Aboriginal title land, somebody owns it, and therefore there has to be some method of governing it. Well, you look to the First Nation. That's who's going to govern it. Or in other words, the group who wins the case, who wins the Aboriginal title case, they're going to be the ones that run the show with respect to the rights to that land. But it's not comprehensive. It doesn't mean that everything else about for example, I'll give you a good example. The courts of British Columbia still have jurisdiction on Aboriginal title land. The British Columbia Supreme Court can still make a decision about who can do what on Aboriginal title land. It's just that we now know that what they're going to say is only the Nuchatlet can log the trees. Nobody else can. But who's going to make that decision? What court decides that? It's still the British Columbia Supreme Court.
So I asked this with regards to resource management, because if I'm not mistaken, Canada took the longest time to sign or to agree to adhere to the UNDRIP on an international level. And one of the reasons, or two of the reasons that they had mentioned, was they cited developmental issues and ongoing multiple land disputes in the country at that time. Now, coming back to the question of why I ask, is the government, or the Executive Council, able to revoke any of these titles, or step in and say that, okay, this is resource, we need to manage it better, or we need to get in here and do this on a larger scale? Can that be a possibility?
It's a very remote possibility. It has to be what Canadian law says is that you can only expropriate Aboriginal title if there's some overriding, compelling national interest involved, and that doesn't include economic interests. So in the most extreme case, you can imagine an area of Aboriginal title land that's of strategic importance in a time of war being taken up by the military temporarily until the hostilities are over. That kind of thing. So yes, there is a loophole, but it's not a big loophole. That military example doesn't ring much of a bell because we're not at war with anybody. But I give it as an example of the fact that no rights are absolute, not even Indigenous rights, and if there is a compelling case, and that's why we have courts. That's the tough job of those judges, is to figure out when to draw those lines.
Thanks for that, Jack. At this point, does anyone in the audience have any questions for Jack? We do have a couple of minutes that we can spare for this.
I have a question.
Hey,
I'm a colleague of Binny's. I'm a reporter with Black Press, and have followed quite a few of these court cases over the years, reading some of them for my thesis and some as a reporter. And it always comes up in court cases that, oh, this isn't the venue to discuss that problem. Your problem's not with the court, your problem's with DFO, your problem's with, oh, did I?
No, you're still there.
Oh, I'm still there. Okay, I saw somebody wave. I thought I was on mute. And it always seems that the court says, you have a valid dispute, but we're not the ones who can sort it out for you. You have to deal with it between the organization. So my question to you is, what's the alternative for First Nations to battle these things out in court, given that it is expensive, it's slow, and often the answer is, sorry, wrong place.
You're asking the wrong guy, because my view is that courts are the cheapest, the quickest and cheapest way to solve these disputes. And I've proven that, right? I mean, the fact is that all of the other processes take longer and cost more. The most dramatic example was the British Columbia Treaty process. Unfortunately, I mean, it was lots of goodwill. It was set up originally at the tail end of a Liberal government, and then it was picked up by the new NDP government that was elected in was it 1991 or so. We have Colin Gableman here in the room. He would know. And with a lot of goodwill and a lot of good intentions, the BC treaty process was set up, and millions of dollars were spent, hundreds of millions of dollars were spent in fruitless negotiations. And the reason is that the parties were thrown into the rooms to talk to each other without any mandate. And the mandate is only going to come from court decisions. So what did I do? I went to court. I mean, it took a long time, but we did take the Chilcotin case to court and got a successful decision, opening the doors for other people like the new Chatlet who are in this room with us today, for them to go to court. And, you know, it is a slow process, but it's not as slow as the 145-year history we've faced to date. The courts, in fact, turn out to be, you know, on the longer conversations, Zoe, but the courts turn out to be quicker and less expensive than people who have no reasonable mandate and no opportunity to settle these difficult, intractable claims, sitting in a room talking to each other. They're not going to solve it.
Mm-hmm.
You need a judge. You need a judge to say, this is the law.
I don't want to take other people's time, but I do have another question that is not really related to title, but related to Indigenous law. So there was a small case, not even a case, it was a request for an injunction that happened with the First Nation here that was just denied. And one of their arguments is that according to our Indigenous law, the fishery in this area should be closed. And the judge said, sorry, I disagree. And so what's happening in BC right now with First Nations being able to assert Indigenous law and have it be respected? I know that there's movements in various places across Canada. I'm just wondering if you can talk to if that's being respected in our courts here, or if it's still in early stages, or where are we at?
Yeah, you hit the nail on the head with early stages. Canada is a remarkable country because Indigenous law is and always has been a part of Canadian law. So customary law, that, you know, we think if you study law, you think customary law and you think of old England, right? The right to walk across the Lord's pathway or something. But in fact, customary law, the biggest place in the world where you'll find expression of customary law is Canada, because for 600 tribes across Canada, their customary institutions are embodied as part of Canadian law. Now, that sounds like a brave statement in the face of situations that you just described where those customary laws were not applied. The trouble is that the location where those laws can be exercised has been greatly restricted by the fact that First Nations often only have jurisdiction over tiny bits of land called Indian reserves, just little areas of land. There's no problem with customary law on Indian reserves. It always applies, it always has applied. But it's only when the First Nations can expand their land base to its rightful size that the customary laws will apply in a larger territory. They don't apply. Those customary laws just don't apply generally in the face of non-recognition and, in fact, pretty vigorous opposition by the majority culture.
Does anyone have any more questions for Jack?
I've got my hand up there. Can you see it?
Hey, David, I can now see the hand.
Just a quick question. Jack, would you mind speaking to fisheries rights and law, please?
Fishermen's rights?
Fisheries rights.
Fisheries. Yeah, fisheries is first of all, the right to fish, that is the Indigenous Aboriginal right to fish, has always been a part of Canadian law. It still is. And so First Nations, of course, on this coast in British Columbia, have the first claim on fishing, on the return of a healthy run. And so we know that in order to have a healthy run of any species, there has to be habitat where those fish can spawn, and there has to be a healthy environment for the fish to live in. And you can only take a harvestable surplus, that you can't take all the fish. And so you look at what is the harvestable surplus each year, and And the First Nations have the first claim on that. And that's always been the law. That's never changed. That's been the case since Canada was invented. But there's, of course, problems because the commercial fishery is valuable and there's conflict about who gets what. And also there's been, I think it's fair to say, incredible mismanagement of the fisheries. And you only have to look at the east coast of Canada where, you know, one of the world's greatest natural food resources, that is the cod fishery off Newfoundland. I mean, it really was a magnificent food resource discovered by the Europeans 500 years ago and exploited to virtual extinction. That's just a tragedy. And I'm really hoping that doesn't happen here in British Columbia, where we have another fabulous natural food resource, which is our salmon runs, multiple different species and multiple different runs going up all the different rivers of British Columbia. And many of them are in peril, and that's a tragedy. But who has the right to enforce that? The first claim, the first right to enforce the health of those runs is to the First Nations. And thank goodness. I mean, it saves those salmon and it saves that environment because there's somebody there who has the rights that override the Department of Fisheries and Oceans in Ottawa. The local First Nations have rights that are take priority to that.
Jack, I do have a question coming in from Roy Hales. It's the first part of the question that he had asked. He's the editor at Cortes Current. Most of what has been said was from the point of view of Canadian law, but does the fact that most First Nations land was unceded change anything? Because some First Nations people still say that the title is theirs.
Well, First Nations are, first of all, they are Canadians, and they are British Columbians, and so they are part of Canadian law. There's not a distinction between First Nations law and Canadian law. It's all one body of law, and under that general system of law, First Nations have rights that are they've had difficulty enforcing in the past, but they're gradually making progress. So, but we're still in the beginning, the very beginning of that. Like, you know, it's like there's this big estate that needs to be distributed, and we haven't only just begun to read the will. You know, we haven't really got there yet. So, but that's what it's really like. It's just a big problem of an unresolved disposition of the land that belonged to the ancestors. So, you know, I don't draw a distinction between Canadian law and Indigenous law. Indigenous law is a part of Canadian, always has been a part of Canadian law. It built right. Remember what I said about the Royal Proclamation of 1763, that right on its face, it says the King George III said, I'm setting up courts. By the way, it wasn't George III. He signed it, but it was a liberal, actually a progressive British cabinet during the Age of Enlightenment that set this up. This was an Enlightenment document, the Royal Proclamation. Canada has the benefit of a transitional change happened back in 1763. When you look at it, they set up courts to enforce the rights of the inhabitants who were Indigenous people. So they said, first of all, those Indigenous people have rights. They have the right to the land, and we're going to set up courts to enforce those rights. That's what Canada's Constitution, the first Constitution of Canada, that's what it says.
We do have one last question. We're almost towards the end of our time, but that's from Michael Maskell. Michael, would you like to ask the question, or shall I read it out for you?
Sure. Thanks, Jack, for doing this. I was just interested in when the First Nations go to court to establish their claims on the land, they have to fight both the federal government and the provincial government. And it's seemingly sort of intentional that the federal government fights against the provincial and the provincial fights against the federal. And overall, it's just a huge delay tactic. How do you deal with that in a way that, you know, makes it more expeditious, perhaps?
Well, you know, I'm starting to sound like it's all good news, and it's not all good news, but there is some good news there. First of all, procedurally, there's now a recent change that those kind of claims the First Nations don't need to sue against the federal government for their land claims. That's just against the province. So that's a recent change. Secondly, if the federal government is involved, when Judy Raybould Wilson whose house I can actually see her house from where I'm sitting here. She lives over on Quadra Island, and I'm in Campbell River looking across Discovery Passage here. And Judy Raybould Wilson was the Minister of Indigenous Affairs in Ottawa. She lost her position there, you may recall, but the day before, maybe 3 days before she lost her position as the Minister of Indigenous Affairs, she passed a directive to Crown Counsel that still stands, and it says to all Crown Counsel, all federal Crown Counsel in Canada, it says, first priority, if you can admit an Aboriginal right or an Aboriginal claim, look at it carefully. If you can admit it, admit it. Don't fight it. So that's still the directive, and I've seen some change. This is recent, just in the last couple of years. I've seen some change as a result of Jody Raybould Wilson's directive to Crown Counsel. Crown Counsel, federal Crown Counsel, that is, are much more receptive to these claims. They actually look at them and say, "Wow, there's some merit in that case. We're prepared to admit the right rather than fight it." Now, I wish that the Attorney General of British Columbia would give the same directive to his Crown Counsel, because that's the sensible thing to do. If somebody has a valid claim, and if they're going to win the case, you should admit that. You know, all lawyers do that all the time, except in this field. And they used to do it in this field. I just tell you a little tiny anecdote if we have time, Benny. I was talking yesterday to Tom Berger. Tom Berger was the great British Columbia lawyer who created this field of law when it became legal to do so. And when he did the Calder case, he went and talked to the Crown Counsel, and they had a meeting at which they discussed, okay, now here's what the Nisga'a are claiming, and this is what you could say in resistance in your statement of defense. Couldn't you just admit some of those things? And back then, in 1969, they did admit some of those things. They made some admissions, and that trial only lasted a week instead of the Chilcotin trial, which lasted 339 days. It only takes a short amount of time to do these cases if people are reasonable on both sides. Unfortunately, we have a situation where Crown Counsel in British Columbia, based on long ingrained habit that has not yet been changed, the long ingrained habit they have is to simply say no, 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 and no. And I'd like them to actually take a more reasonable stance and start saying, well, you know what? Yes. That's what the federal Crown Counsel are now ordered to do. And I'd like to see that in British Columbia. Anyway, thanks for asking that question. That's my long-winded answer to it.
Thanks for the answer.
We have one question from Archie. Archie is a counselor within the Nuchotlik First Nation. And Archie, I'm going to ask you to unmute.
Thank you. It's not a question, really. It's just to, and I thank Jack for what he's saying, but you know, I want to give the history of why Nuchotlik is where we're at. We had and I'm going to speak English here, so everybody will understand. We had a chief by the name of Walter Michael. He passed, but he gave me direction to go and go talk to Jack Woodward, so we could go to court. And the only reason, the specific thing he said was, we used every square inch of our territory. It was not just the small reserves, but I want to thank our ancestors who have given us what we have. We have our chiefs, the late Felix Michael, who dates back to the 1700s, with Albin Michael, Walter Michael, and now Jordan Michael. We're a government that keeps one family as our chief, and I want you guys to know that I've been through I live with the Indian Act. I've been through the residential school process for 13 years. So I'm a living example of what happens, and I'm still healing from that process, which is okay because I'm a lot healthier. But we believe that we own it, we manage it, we protect it, we enhance it, we access it, and we share it. And we're at the stage now. We have a saying in Anuchannel. We have a saying where everything is connected. You know, we mentioned forestry today, but we look at the impacts of what those forestry acts have done. Look at how they mismanaged, the forestry so much. It impacts our rivers. It impacts our salmon. It impacts our watersheds. It impacts our drinking water. And there's pollution, soil coming off the mountains. So it needs to be better managed, and that's what we're all about. We always believe that local management, local decisions, local benefits, because we live with non-Aboriginals that are our neighbors, and we want to work together and share, and we all benefit. Not going on a big ship and going across oceans, that's just not right. But we also part of, to me, one of the biggest resistance to First Nations management and ownership, part of that comes self-sufficiency. People want to babysit us because they want to own something that we own. But they want to say, well, it's ours and you can just have a little piece. No, we were self-sufficient. My dad and my grandfather, growing up in Nuchatlet, we didn't have to go anywhere. We didn't have to travel anywhere. We stayed at home because our territories were wealthy. They had everything. We didn't need to go to, Hot Springs Cove to access salmon. We had lots right at home, halibut, lingcod, So to me, it's and with the treaty process, to me, the biggest problem was because they wanted us being round to fit in a square hole. Plus the mandate, the lack of mandate, but they wanted to control us even through a treaty, by saying we have to fit in their mold. And we said, no, we can do better than that. We can help each other and do better. And so there's lots that, why we're here, that, we want to do a lot better, because everything we do impacts all down the line. And we're at that time and space where we have to manage very, very carefully because of climate change, because of ocean warming, nature being so out of balance. How do we deal with that? We have a big job to do, and we have to do it together. Thank you.
Thank you, Archie. Thank you for sharing your views with us. We're almost at the end of our time, but we do have a couple of minutes. And Jack, we have a question from Joyce Trevor, who has asked if you can explain about the overlapping First Nations territories and how do you think can this be resolved within the context of rights and titles?
Well, overlapping claims are a problem, and I don't have a quick solution for that. What I have relied upon is old documents that don't seem to show overlap. So in the Nuchatlet case, we're relying on Philip Drucker's book. This is a book written in the 1930s, published by the Smithsonian Institution. It's called the Northern and Central Nootka Tribes. And when Philip did his work, he was an anthropologist, based on interviews he did with First Nations, some people who were born in the 19th century. And he drew maps, including the map that we're relying upon in the Nuchatlet case itself. And when he drew those maps, they didn't show any overlaps. And that's the maps that we're going to put in front of That's the map that we'll put in front of the judge. You can't really see it in this, but it shows the Nuchatla territory, and that's the territory that we're claiming, and it doesn't show any overlap. It shows a clear line. Unfortunately, so much time has passed but after the denial of title that history, people's memories get confused and history muddles things. And so you have, but let's not put the cart before the horse. Overlaps are a problem. The bigger problem is the main areas of ownership. That's the bigger problem. Let's solve those. We'll solve overlaps in due course.
Well, thank you so much, Jack, for agreeing to do this and for agreeing to touch upon these topics, which many of us may not be aware of or have half knowledge about. So thank you once again for sharing your expertise on and helping us understand the rights and title of Indigenous people better. And thank you all for joining in, taking time, and participating in this group meeting. We hope to hopefully see you soon again.